The federal government is now a plaintiff in the lawsuit against Southern California Edison over the Eaton Fire. What that means for the thousands of people who've already sued the utility, trying to blame them and hold them responsible for igniting the fire. It's the Leonard Files podcast. I'm investigative reporter Eric Leonard from NBC Los Angeles. A bit of a surprise announcement this week from the U.S. Attorney's Office in Southern California. That's the federal prosecutor that we usually talk about in the criminal realm. The federal government is the one that brings big indictments against gangs, and more recently, in the last few months, lots of enforcement of federal immigration law. This time, the acting U.S. attorney in Southern California has announced that he is pursuing the filing of civil litigation through the U.S. Attorney's Office Civil Division against Southern California Edison, trying to hold it financially responsible for two Southern California wildfires, one of them in the Inland Empire, but the one that we've been paying so much attention to, the Eaton Fire from January that burned through Altadena and has already led to some 5,000 individuals and businesses filing lawsuits against the same utility. So what is this going to mean for those cases? Because all of those lawsuits are happening in state court, where the timelines are a little bit slower. This case has been filed in federal court, where things generally go from initial filing to in-court happenings much, much more quickly. So here to help us break all this down, Mike Artinian, you're an attorney. You represent a number of plaintiffs in the Eaton Fire litigation in state court. Who are they, and how are you more broadly mixed up in this massive litigation against Southern California Edison?
Yeah, thank you, Eric. We represent individual plaintiffs, which are homeowners, renters, business owners that have been affected by the Eaton Fire. And we filed the first Eaton Fire lawsuit on January 13th, and hundreds of lawsuits have since been filed by various law firms, and we are on the leadership group of plaintiffs' attorneys that are spearheading the case.
So we talked a couple of weeks ago at court because the judge set a trial date, which seems like an eternity of time away from now. Why was that significant, and is that actually an eternity in state civil court time, which is different than normal human time?
Yeah, that's a great question. So two points in time, really. One, we're at the 7-8 month mark of when the fire happened. So relative to the date of the fire, the court setting a trial date a couple weeks back is actually very good in terms of timing. It's a very quickly set trial date. Sometimes judges will want to see how the parties progress in terms of discovery before they set a trial date. But this judge was decisive and decided to set a trial date in January of 2027. Now, we also had asked for an earlier trial date to be set than January 2027. We asked for June of 2026 for a trial date. So just at the last status conference hearing, we again asked the court to set an earlier trial date. We're not done trying to convince the court that these cases can be tried earlier than January of 2027. And from a practical perspective, the sooner you set a trial date, the sooner the cases start to resolve.
Right, because it's a point of leverage, I guess, for everybody involved. If there was a prospect of avoiding a trial, it's like now or never, as opposed to maybe sometime. But one thing I wanted to clarify, because I think this is really interesting, is at that status conference that I was at the end of August, and I know there was another one this week, the judge was describing how the first pool of plaintiffs in a theoretic first trial are not just randomly selected. Like, there are specific categories of fire victims that are in that group. Who are they, and why are they being picked that way?
Yeah, so that's what's called Bellwether plaintiffs. And bellwethers are essentially a sampling from various damage categories, such as, homeowner burn downs, homeowner smoke and ash. You have renter burn downs, renter smoke and ash. You have business losses. You have evacuees, you have personal injuries, and you have wrongful deaths. So the first set of 50 or so plaintiffs that are going to be set for trial are going to be a sampling from each of those categories.
And wasn't there also an issue with accelerating the cases of the people who are most elderly? Or did I not understand that correctly?
No, you understood that correctly. It's what's called a preference plaintiffs or a preference trial for certain elderly and infirm plaintiffs that require an earlier trial setting. So that was part of the reason why we had asked for the June trial date for 2026. And the court indicated that the first 50 plaintiffs will involve a mix of the bellwethers as well as certain preference plaintiffs so that they could have, priority in terms of trial setting. But that issue is really not fully resolved yet because there's a motion that's required for a preference trial. And there's some statutory requirements in terms of how quickly the court has to set trial dates for preference plaintiffs if the court grants that motion. So there's still some decisions to be made with regards to the preference plaintiffs.
Got it. And so the timeline, which I think to the average person seems like a trial more than a year away, seems like a really long time, especially for people, because I think almost everybody in Southern California knows somebody whose life has been turned upside down by one of these two fires. The people who are the victims of the fire are trying to get their lives into some sort of normalcy. The idea that it might take that long to even begin to approach the prospect of a recovery for them, it seems like a really long time, but like you're saying, it's actually not that long in litigation terms.
That's true. Obviously, we would have preferred an earlier trial date on the plaintiff's side. It just means that the cases would likely get into resolution mode a lot sooner. I think that SCE had asked for a later trial date, even into August of 2027 is when they asked for a simple reason. There is a program that they've announced without any details yet as to them trying to resolve cases with some people for undisclosed terms. We've had experience with some of these types of programs in other litigation, and typically it's a very low participation rate because the offers of resolution directly by SCE, basically curtailing the litigation process, are for pennies on the dollar.
Right. And this is, I'm sorry, I didn't mean to interrupt you, but just for clarification, SCE announced, I think it was about 6 or 7 weeks ago, that it was going to offer to settle fire claims directly with fire victims or via their attorneys without going through the trial, but it's without also all the stuff that is going to be discovered in preparation for the trial, and ultimately without any evidence that might weigh into, I suppose, how liable they might be if, in fact, it's established that they started the fire. And they haven't announced the terms yet. I think that's the most important thing. They said it was going to happen in the fall. We're getting close to the fall, and we haven't seen what those terms are. But I imagine you're advising your clients that they're much better off waiting, even though the big prospect that SCE would be offering is an immediate payment.
That's absolutely right, Eric. I mean, I think, if a program comes out and it's fair resolution, we'll be the first to talk about that. But I have my doubts that that's the real incentive and intent behind what SCE is doing here. I think the timing is key to look at, right? So they asked for a trial date way out. They're not admitting liability by creating the settlement program either. So it's a non-admission of liability settlement program for undisclosed terms. For example, what's the price per square foot they're going to offer? What are they going to offer for emotional distress damages? The non-economic damages are a big part of these cases that SCE typically likes to ignore.
Right. All right. Well, we'll keep on SCE and see if we can get any closer to the actual terms and keep updating that as those details come out. But again, they haven't announced it yet. All right. Let's turn to the announcement this week from the federal prosecutor in Southern California, which I think caught a lot of people off guard, not for what they did, but the speed with which the U.S. Attorney's Office did this. And I'm talking about, let me see if I can pull it up here. This is the lawsuit that was filed by the Civil Division of the U.S. Attorney's Office against Southern California Edison. There were two lawsuits about two different fires. The one we're focused on is the Eaton Fire, because that's the one we're talking about. And there were some interesting things in here about how the federal government is trying to recover costs that it incurred both in firefighting and in damage from the fire, which is not unusual. The federal government files these cases routinely when there is a loss to federal land or federal property. Typically, though, they've been filed some time later, especially after there's been a conclusion from some sort of law enforcement investigation as to the cause. And what I thought was really interesting in this, I'm just going to scoot down here, is that the federal government, so now it's not just the fire victims, civil plaintiffs, attorneys such as yourself, the federal government is saying this was caused by SCE. Is that a surprise to see in black and white in a federal lawsuit this soon?
Absolutely not. And here's the thing. If you listen to the U.S. attorney in his press conference and you also read through the complaint, you'll see them quoting SCE. And the reason why I think they filed this one so quickly as opposed to the other one that they filed, I think it was in the Fairview fire from 3 years ago.
And Bobcat fire from a few years before that. But yes, go ahead.
Right. Then I think the reason why they filed this one so quickly is because there is such strong evidence of SCE's liability. We have clear video footage of the arcing and sparking that created the fire. And you also have SCE's executive team commenting upon this in the media, that induction theory is the leading theory and that there's no other evidence that it was anything else but their lines.
Right. So let's just be clear about those items. The SCE's filed a few different disclosures with the California Public Utilities Commission. And in, I think, the second of those filings early on, right after the fire, they acknowledged that they were investigating whether or not their equipment was involved. And then there was a statement that was more investor-oriented, which I think is the one you're referring to, where they acknowledge in pretty clear terms that somehow, some way, their lines, their gear was involved in the same moment when the fire ignited. I've never seen anything quite like that. Usually the statements are a little bit more obtuse. But both of those, like you said, are quoted in the federal complaint saying SCE is to blame. So I guess, does this in any way, having the federal government reach the same conclusion I know you and your co-counsel and many of your clients probably did months ago, that SCE they believe is responsible, does having the federal government now jump on into that pool change anything in the state case?
I don't think it changes anything in the state case, but I do think it solidifies the theory of liability that's been asserted by our law firm, other plaintiffs' law firms, other entity plaintiffs, such as the county, Pasadena, Sierra Madre, and other public entities. I think everybody knows what the evidence is, and it's not surprising to me that the U.S. government has already jumped in.
I'll stop showing you paper in just a second, but the other thing that I thought was interesting that hadn't occurred to me before that was in the complaint is that is this part here, which is that Southern California Edison did not just allegedly, according to this complaint and yours and all the others, destroy all of these acres of national forest land, but Edison already had a pre-existing relationship with the federal government because it had to have a permit to string all of their high-voltage power lines through the Angeles National Forest and all the other national forest land where their lines exist. And so I wonder, does the fact that they have these obligations, according to the complaint, it says that under an easement and the SUP, which stands for Special Use Permit, not only does SCE have a duty to try to prevent fires on national forest land, but that they're also immediately liable. Does that relationship, do you think, have anything to do with also the speed with which the federal government has stepped in here and filed this case?
It may. In terms of that easement you're referring to, SCE has an easement with the U.S. government for its power poles. And so I don't think it's surprising that the additional causes of action for breach of the easement and for indemnification based on those easement agreements has been asserted. And so those are separate causes of action from what the individual plaintiffs have. Obviously, we don't have those direct contractual relationships with SCE in terms of its power poles and the forest there. But it's not surprising to me that they immediately are seeking remuneration for the various causes of action that they have asserted, which include breach of the easement, the indemnification, and negligence.
So two more things, and I'll let you go because I know you're busy. First of all, one of the things the U.S. Attorney said at the announcement this week was that he was going to make sure that SCE did not stick its ratepayers with the cost of whatever the legal liability turns out to be. And we've seen the enormity of some of these legal bills in some other recent wildfires. This one is potentially going to exceed that by multitudes, given the losses here. How can he make that promise? Because it seems to me that any of the CPUC regulated utilities, SCE is one of them, it's a private business, but it's regulated by the state of California. They can go to the CPUC and say, gosh, what are we going to do? We gotta raise our rates and have all of our ratepayers share the cost of this. That's happened before. It's happened for things that are non-fire related, like the decommissioning of nuclear power plants. There's a special assessment that appears on people's bills for that. So how can the U.S. Attorney say that they're going to prevent, his office will prevent that from happening if there is indeed a giant payout and SCE's liable?
Well, the system, the way that it's set up right now is that there is a wildfire fund in California for a situation just like the Eaton Fire that was created back in 2019, in essence, to protect utilities like SCE, SDG&E, and PG&E from going bankrupt if there is a mass tragedy like this. And that fund is something that is available to Southern California Edison unless the CPUC finds that it acted imprudently. So you can see the statements in the press by SCE speak to that issue, especially when they're talking to their investors by saying that even if we're liable, we acted prudently. Well, why did they use those words? It's because of the wildfire fund. So if they're able to invoke the settlement fund in California, that means that the CPUC cannot find them to be imprudent. And so if they recoup the settlement monies that they pay out through the settlement fund, then there's going to be no finding by the CPUC that they've acted imprudently. So that's the key issue here, that SCE is speaking to its investors to make sure its stock doesn't plummet by saying that even if we're liable, that we acted prudently. In other words, they're telling their investors, hey, even if we're liable here and we have to pay out billions of dollars, we are going to be able to recoup a lot of that through the wildfire fund.
Got it. All right. Lastly, I'm sure you've been in contact with your clients here, the fire victims, as these things have developed in recent weeks. On the whole, I mean, everybody's got an individual, unbelievable story. But on the whole, how is everyone feeling about the way that this case is going?
Yeah, that's a great question. So we hold town hall meetings at the Scottish Rite Center twice a week in Pasadena on Wednesdays and Saturdays. And so we get a good feel from not only clients that attend, but also community members that are attending for additional information, that people are obviously frustrated and want to know what their rights are and when resolution is going to be had. And so we put on a thorough presentation just going through all of those issues, from liability issues to the status of the litigation to how the trial date being set impacts resolution and what damages everybody can collect in this case. So people generally, obviously, want to get their lives back on track. And the only way to do that is by resolution and getting into a resolution protocol with SCE that actually pays fair compensation, not pennies on the dollar.
Before we go, I'll play you a little bit of the U.S. Attorney's announcement from this week on filing this lawsuit. Not a lot that we haven't already covered, but just so you can hear it for yourself. Here's Acting U.S. Attorney Bill Iseli.
Today, my office filed 2 civil lawsuits against Southern California Edison in connection with 2 separate wildfires, including the Eaton Fire that devastated the city of Altadena in January, resulting in 18 deaths and more than 10,000 structures damaged or destroyed, leaving part of that city looking like a bombed-out war zone. In addition to the lives and homes that were lost, losses that are irreplaceable, the Eaton Fire burned nearly 8,000 acres of federal land in the Angeles National Forest, land used by hundreds of thousands of people every year for outdoor activities such as hiking and camping. It is also an area of natural beauty near our nation's second largest city. The Eaton Fire lawsuit alleges that Southern California Edison negligently failed to properly maintain its power and transmission lines in the area where the fire ignited on a windy night in January. Negligence that had deadly and very costly consequences.
I wanted to make sure I also mentioned the Southern California Edison response to the announcement of this lawsuit by the U.S. Attorney's Office. It said in a very short statement, "The Eaton Fire was heartbreaking for so many of us who live and work in the Los Angeles area. While the cause of the fire is still under investigation, we will review this lawsuit and respond through the appropriate legal channels." That's the brief statement from Southern California Edison. The U.S. Attorney's Office, again, filing this lawsuit very similar to the cases that have been filed by the thousands of fire victims in state court. Again, this is in federal court, which means the timeline for when this might get in front of a judge, when there could even be a jury trial, might be much quicker than in the state court, which, as you heard Mike, the attorney, talking about, is now set for the first trial. Not everybody, but the first trial, January of 2027. So I'm going to leave it there for now. The other big question, by the way, for the U.S. Attorney's Office was what's going on with the Palisades fire. That investigation is still ongoing. No announcement has been made about how it started or who might be responsible. By the way, that's the same for the Eaton Fire. The feds aren't investigating the Eaton Fire. It's L.A. County and the state of California that's looking at the cause of the Eaton Fire. Nothing's been announced there, even though, as Mike, the attorney, and Bill Asaley, the U.S. attorney, have been talking about, they believe the evidence is overwhelming that it will land on the shoulders of Southern California Edison. So we'll keep following all of this. Be sure to click subscribe on our YouTube page so you don't miss our upcoming episodes. I'll see you next time.